And I have the great pleasure of serving as the Chief Executive Officer of the Chautauqua Foundation. It's my pleasure to welcome you here. I know some of you have probably been here since about 1 o'clock this afternoon, so enjoy. This afternoon marks the 8th year of a partnership with the Robert A. Jackson Center to present each summer a lecture on the Supreme Court. Through the efforts of the Jackson Center, we have been able to bring to Chautauqua some of America's most distinguished scholars and Supreme Court practitioners, and this year is no exception. My responsibility this afternoon is to introduce you to John Q. Barrett, the Elizabeth S. Lene Fellow at the Jackson Center. Many, if not all of you in the Chautauqua tradition heard John give this afternoon's interfaith lecture, so I shall be brief. John will introduce you to this afternoon's speaker, who I should mention will have a book signing following the speech this afternoon. John Barrett is a graduate of Georgetown University and Harvard Law School, and he teaches law at St. John's University. He is the editor of That Man, an Insider's Portrait of Franklin D. Roosevelt, Justice Jackson's previously unknown memoir of FDR and the New Deal. John is currently working on a biography of Justice Jackson, which will provide the first insider's account of his year away from the Supreme Court, serving as the chief American prosecutor at the International Military Tribunal in Nuremberg. I would ask you to please join me in welcoming back to this podium Chautauqua's very good friend, John Barrett.
Thank you, Jeff. Long time no see, right? I will be very brief. Robert Jackson was born in Spring Creek, Pennsylvania, but when he was a boy, his family moved across the New York state line. He grew up in Frewsburg, and then he went, after graduating from the Frewsburg High School, for a postgraduate year at the Jamestown High School. And that's where he met Jamestown as an environment and Chautauqua Lake, Chautauqua County, and Chautauqua Institution as part of his higher education. He was tied to this place for the rest of his life. He was a lecturer, he was a student in the audience. He was a guy fishing in the lake, he didn't play golf, but he became a real friend of the institution at every level, including in the 1930s when it almost went under. He was instrumental in persuading President Roosevelt to live up to his promise to come here in 1936, which was a big gate. That was I Hate War. One of Jackson's first major lectures following Nuremberg was 4th of July, 1947, in the amphitheater, where he explained what the Nuremberg trial had been about and had hopeful things to say about the future of international relations at a time when a World War III with the Soviets was feared by many. Jackson died in 1954, and his funeral, first in the National Cathedral, was followed by a return of his body home to Jamestown. And after they buried him down in Frewsburg, the justices of the Supreme Court, all of whom had traveled up here by train, said, we have to see Chautauqua Institution. You know, our beloved late colleague Bob has been talking about this place for years. And so although it was October, and they probably needed to find somebody with a key, because there wasn't a post-season residential community like there is now, Jamestown Bar Association members, lawyers, as drivers, snaked through the grounds and brought Earl Warren and the 7 surviving associate justices here, to sort of see the place. The fall colors, I'm sure, were gorgeous, to kind of breathe the air and hear the echoes and get a little bit, at least, of an off-season feel of Chautauqua. I don't know if any of those ever returned, but many Supreme Court justices and Supreme Court connected people have been here. Thurgood Marshall spoke here in 1957 when he was still with the NAACP. Stanley Reed spoke here in 1937. Justice Kennedy, of course. Justice O'Connor, of course. And in that arc, this lecture series is a happy continuation. I'm grateful to Chautauqua Institution for really seeing and seizing the opportunity to include in the reflections here a discussion of the Supreme Court in this summer moment following the completion of a term, bringing real luminaries, real top-flight talent to converse with you and all of us about the work of the court. This lecture series is named in Justice Jackson's memory, and this is the 8th annual Robert H. Jackson Lecture on the Court. The predecessors are a who's who roster of stars in scholarship, in litigation, in analysis, and court following. Jeffrey Stone, Linda Greenhouse, Jeff Toobin, Seth Waxman, Adam Liptak, Jeff Schessel, Dahlia Lithwick. I hope many of you were here in past years for many of those lectures. We're right in the same place or higher this year with the 8th Annual Robert H. Jackson Lecture. Pam Karlan is a professor at Stanford Law School. She is an active litigator and scholar of the Supreme Court. When Justice Souter announced his retirement in 2009, the immediate media speculation seemed to focus on females and seemed to have a short list, and one of the names in that conversation was Pam Karlan's. Pam Karlan turns a great phrase, you'll see that in a second. And she said, "I am flattered, but I'm not fooled." And indeed, Justice Sotomayor got that job, and the next vacancy went to Justice Kagan. And, you know, good luck to both of them, and good luck to Pam Karlan, where she continues to be in a very energetic, multi-dimensional kind of teaching, law practice, thinking, and public education. And I think Chautauqua fits right in with all of this. She also had heard about this place for years, but had never gotten here. So we've kind of checked a box for her. She's one of the people who, I mean, literally, I'll read everything she writes. Every time she's on TV, I'll stop and watch everything she says. Every time she's on the radio, I'll listen to it. She's that good, and it's really an honor to introduce her to give this Robert H. Jackson Lecture on the Supreme Court. Pam Karlan.
Having me here. You might have seen I also got quoted recently in the New York Times in an article about the slow pace of Barack Obama's nominations to the lower federal courts. And there was a reporter for the Times called me up and said there was all this talk about my being nominated for the Ninth Circuit and nothing came of it. And he said, "Do you have any idea why?" I said, "Well, I'm not no more liberal than Justice Scalia is conservative. I believe in America, I believe in capitalism, I believe in criminal law. I'm not an anarchist." And I think that may be why I was not nominated. So it's an honor to be here today and to give the Robert Jackson lecture. In an obituary tribute to Justice Jackson that was published in the Stanford Law Review, my home law review, shortly after his death, the justice was praised for, among other things, knowing how to talk persuasively to a jury of Chautauqua County farmers. I do not see a lot of farmers in the audience today, but I am hopeful that I can speak half as persuasively about him as he spoke about the law, because what I'm going to be talking to you about is the justice and his influence on the most pressing constitutional issues of our times. In a way, and in an ironic way, Justice Jackson's DNA is baked into the current court. His final year on the Supreme Court, his final full term on the Supreme Court, one of his law clerks was a young man named William Rehnquist, who later became Chief Justice of the United States. And when Justice Rehnquist was on the Supreme Court, one of his law clerks was a young man named John Roberts, who is now the Chief Justice of the United States. So you might think of this Chief Justice as the kind of grand clerk of Justice Jackson, although as I think you'll see, they had very different views. I want, as my starting point, to begin with one of Justice Jackson's most famous aphorisms. Justice Jackson was probably the best writer ever to serve on the Supreme Court, the most elegant writer to serve on the Supreme Court. And I want to begin with one of his most famous phrases. It comes from a set of cases that were decided by the court in 1953 under the name Brown against Allen. These were habeas cases. That is, they're cases in which prisoners who were convicted in state court are trying to challenge their convictions, claiming that the conviction was obtained unconstitutional. Now, Justice Jackson was not particularly sympathetic to these men's claims. Indeed, he voted to uphold all of their convictions. But along the way, he wrote the following. I just want to read it because I think it is something we've lost sight of. Whenever decisions of one court are reviewed by another, a percentage of them are reversed. That reflects a difference in outlook normally found between personnel comprising different courts. However, reversal by a higher court is not proof that justice is thereby better done. There is no doubt that if there were a super Supreme Court, a substantial proportion of our reversals would also be reversed. We are not final because we are infallible. We are infallible only because we are final. That point, that the Supreme Court is often given the last word on constitutional controversies, not because the justices possess special wisdom, but because there has to be an end to the dispute, at least for now. I mean, we've got to reach a result and move on, is a very important point to remember that we have lost sight of since the days of Justice Jackson. And in the final word, the Supreme Court is not the final word on what our Constitution means. We, the people, are the final word on what the Constitution means, because the justices' views on issues like what counts as equality, what punishments are cruel and unusual, and what liberty means, are necessarily a reflection of the society in which they and we live. We make the Constitution what it is, and we make the justices what they are. The Supreme Court is an institution made up, as you heard in John's lecture earlier today, of people who are appointed. They are not anointed. God did not put his finger down and pick them, no matter how much some of them may think that. And the result of that is we have to remember they are not infallible. Even if you come from a religion that has a doctrine of infallibility, the Constitution is not that religion. So if the Supreme Court isn't infallible, when should the justices intervene to overturn the results of the democratically elected branches and strike statutes or executive branch policies down? And here, I think Justice Jackson's very sophisticated answers have some major lessons for our time. So let me pause for just a moment before I get into the meat of what I'm going to talk about now. How many of you are lawyers and willing to admit it? Okay, not many of you. So I'm not going to be using very much in the way of technical language. I think everything will be very comprehensible to you, but I just want to pause for a moment and say one thing about nomenclature, which is when the Supreme Court or the justices issue opinions, there are a lot of different kinds of opinions they issue, and I'm going to be talking about a lot of different kinds of them. And so let me just give you a little tiny bit of vocabulary. An opinion for the court. What does it mean to say a justice delivers an opinion for the court? It means that at least 5 justices have signed on to what's in the opinion. Justice Brennan was famous for saying when his clerks would come in at the beginning of the year, what's the most important thing you have to know as a Supreme Court justice? And one clerk would say, you need to know about the Constitution, you need to know about the precedent, you need to be able to read a statute, you need to know a lot of history, you need philosophy. You say, no. Most important thing a Supreme Court justice needs to know is how to count to 5. Or as one of my colleagues at the University of Virginia used to say, 5 votes beats a reason any day. So, opinion for the court means an opinion that at least 5 justices have signed on to everything. The second kind of opinion I'm going to talk about is a concurrence. A concurrence is an opinion where a justice has joined on to the opinion of the court, but then wants to add some stuff of his or her own that says, here's how I understand this opinion, here's what I think the implications of this are for the future. Here's where I'll get off this train or this bus if it goes any further. That's a concurrence. Then there's something called a concurrence in the judgment. A concurrence in the judgment is you agree on the bottom line, that is the bottom line result, but you got there by a different route. So concurrence in the judgment would be you took a bus to get to Chautauqua from New York City, let's say, and I took a plane that came through Cleveland. Right? We get to the same bottom line, but we got here very different ways. And then a dissent is an opinion where a justice disagrees with the bottom line. In other words, the court says, let's affirm the conviction of this defendant, or let's uphold this statute, and this justice thinks the opposite. And to give you a sense of how complicated it can be when all of these things get together, I'm just going to read you the official lineup from the Affordable Care Act case that was decided earlier this year. Here's the official lineup. I'm going to take a breath before I start, because I want to try to get through the whole thing in one breath. So I'm going to talk fast, very fast, so if you don't catch all the words, don't worry. Roberts, Chief Justice, announced the judgment of the court and delivered the opinion of the court with respect to Part 1, 2, 3C, in which Justice Ginsburg, Justice Breyer, Justice Sotomayor, Justice Kagan joined. An opinion with respect to Part 4, in which Justice Breyer and Justice Kagan joined. And an opinion with respect to Parts 3A, 3B, and 3D, put in brackets, which no one else joined. Justice Ginsburg filed an opinion concurring in the judgment in part and dissenting in part, in which Justice Sotomayor joined, and in which Justice Breyer and Justice Kagan joined as to parts 1, 2, 3, and 4. Justice Scalia, Justice Kennedy, Justice Thomas, and Justice Alito filed dissenting opinion. Justice Thomas filed a dissenting opinion. Right? And then you're supposed to piece together from all of this what they all actually agreed to or not. And this is not the most complicated one I've ever seen, but it's a pretty typical one for the current court. Now, justices' personalities often come out more fully in their concurrences or in their dissents, because then they're just writing for themselves. They don't have to get 4 other people to join them. And I'll give some examples of that later on in talking about Justice Jackson. But I want to start with a case where Justice Jackson created the frame for the court. In fact, it's the frame in which the Affordable Care Act cases began. And you'll notice I always call it the Affordable Care Act. I don't call it Obamacare. For the same reason that I think the Republicans don't call Medicare and Medicaid Johnson Care or Social Security Roosevelt Care, which is these are statutes. They're not just a policy of a single president. And my story about Justice Jackson's framework begins with a farmer from Montgomery County, Ohio, named Roscoe Filburn. Roscoe Filburn had, among other things, a herd of dairy cattle and a flock of poultry on his small farm. And he sold the milk and the poultry and the eggs. And to feed his herd and his flock, he planted some winter wheat. Now this was during the Depression. And during the Depression, the price of farm commodities had plummeted. And farmers were being forced off the land. And one of the New Deal's responses to this was to try and restrict production. Because, as you know, the laws of supply and demand being what they are, if you decrease production, the price of a good will go up. And the idea was to ask farmers voluntarily not to plant wheat to drive the price up. Now, one of the things that ultimately happened is you couldn't get people voluntarily to do that because people tend to cheat around the edges, right? Because if nobody else is growing it and you grow it, then you can sell it and make more. And so ultimately, the New Deal, one of the New Deal's pieces of legislation was the Agricultural Adjustment Act. And the idea was you would pay farmers not to grow wheat, and they would vote on what the limitations were going to be. And the farmers voted in a referendum to impose quotas on how much wheat individual farmers could grow. But Roscoe Filburn grew more than his allotment and was penalized 49 cents a bushel for the extra 239 bushels he grew. So this is a case, if you do the math, you're going to see this case is going to arrive at the Supreme Court over about $100. And he challenged the penalty that was imposed on him for growing this extra wheat, arguing that the federal government had no power to regulate the wheat he grew on his own land for his own consumption. Right? And sometimes you hear about this case and you think he was like making, like you grew a little basil in the window to make pesto. No, I mean this was, for farm animals. Now his case turned on what the Commerce Clause means. That clause, which is part of Article 1, Section 8 of the Constitution, gives Congress the power to regulate commerce, and here I'm going to quote, among the states. It's what's come to be known as the Interstate Commerce Clause. Now our federal government is a government of enumerated powers. That is, the federal government only has the powers that the Constitution gave it. It doesn't have some kind of inherent power. It just has the powers that the Constitution gave it. So it's critical to determine whether the Constitution gave Congress the power to tell Roscoe Filburn he couldn't grow this extra wheat. Now his argument was that the Commerce Clause gave Congress no power to regulate the wheat because he was growing it and eating it himself, more or less. The wheat was going nowhere, right? The wheat didn't trickle out of his farm into interstate commerce. The Supreme Court disagreed unanimously. And Justice Jackson wrote the opinion for the court. And I want to focus for a moment on 2 features of that opinion. The first feature is Justice Jackson's rejection of the idea of rigid formulas or categories for determining what counts as commerce and what counts as interstate commerce. And he said, I know that there are prior decisions of the Supreme Court that said, well, commerce is when you buy and sell things, so mining doesn't count as commerce because that's extraction. And manufacturing things doesn't count as commerce because that's manufacturing. It's only once you sell the things that it becomes commerce that Congress can regulate. Before that, Congress, the federal government, has no power to deal with it. And he said, I know that that's there, but here's now what he said. Questions of the power of Congress are not to be decided by reference to any formula which would give controlling force to nomenclature such as production and indirect as opposed to direct, and foreclose consideration of the actual effects of the activity in question on interstate commerce. In other words, Justice Jackson was saying, let's be real. If farmers evade the limits by growing and consuming excess wheat, of course that will have effects on the overall national market for wheat and for farm products more generally. Wheat a farmer grows, after all, is wheat that farmer does not buy. And if he doesn't buy that wheat in the market price goes down. And the dairy and poultry products that farmer Filburn was ultimately selling were part of a national agricultural market. So while farmer Filburn's decision taken in isolation, 239 bushels of wheat is not even a rounding error when it comes to the amount of wheat in the United States. So although taken in isolation, his actions have no effect on commerce. If you aggregate those actions, if you ask, what if everybody did it, right? The sort of golden rule theory, then obviously there's an effect on interstate commerce. So that's the first point that Justice Jackson is making, which is, let's be realistic about the effects of people's actions on interstate commerce. And the second point he made, which is equally telling today, comes in response to the implicit criticism, if the Supreme Court doesn't put a limit on Congress's commerce power, who will? As if we're going to have a constitution at all, how can we have a constitution if the Supreme Court isn't constantly saying no to people when they try to do things? And here's what he said about that. At the beginning, Chief Justice Marshall described the federal commerce power with a breadth never yet exceeded. He made emphatic the embracing and penetrating nature of this power by warning that effective restraints on its exercise must proceed from political rather than from judicial processes. The conflicts of economic interest between the regulated and those advantaged by it are wisely left under our system to resolution by the Congress under its more flexible and responsive legislative process. And in a private letter to his future colleague Sherman Minton, the Justice was even more candid. If we were to be brutally frank, I suspect what we would say is that in any case where Congress thinks there is an effect on interstate commerce, the court will accept that judgment. All of the efforts to set up formulae to confine the commerce power have failed. When we admit that it is an economic matter, we pretty nearly admit that it's not a matter on which courts may judge. In other words, constitutional limits are sometimes best enforced through the political process rather than through the courts. As you'll see in a moment, that's not always true. There are some parts of the Constitution that really are designed to protect individual rights against the majority. But the Commerce Clause is not really one of those. And Justice Jackson's opinion for the court in Wickard set the framework for thinking about Congress's commerce power that lasted with very little controversy for 50 years, but which seems to have collapsed this term in the Affordable Care Act cases. 5 justices held that Congress exceeded its commerce power when it enacted the minimum coverage provision, the thing that's often referred to as the individual mandate, the requirement that most Americans carry minimally adequate health insurance by 2014. Now, ultimately, that was upheld by the Supreme Court under a different theory, which is that the individual mandate isn't really a mandate, it's a tax, and therefore Congress's taxing power can uphold it. But the 5 justices who thought there was not a commerce power here purported to see a clear line between action and inaction. That is, they said, if you don't buy health insurance, you're not doing anything, and Congress can't regulate not doing. They can only regulate doing. Does everybody see action, inaction, doing, not doing? But Justice Jackson was right. That is a totally artificial line. That's not a real line. And let me explain and give an example from the Affordable Care Act case itself of why that's true. One of the original plaintiffs who went to challenge the Affordable Care Act in the cases that got to the Supreme Court was a small businesswoman named Mary Brown. That's not like a pseudonym. That's actually her name. So I guess they were looking for somebody who seemed very typical. So Mary Brown said in her complaint she did not want to have to buy insurance for the employees of her business or herself. She said, I want not to act. But on December 7th of last year, her lawyers informed the Supreme Court by letter, the Supreme Court had already decided it was going to take the case, informed the Supreme Court by letter that her business had closed and that Mrs. Brown had filed a petition for personal bankruptcy. Now, you can actually go online and read the petition, because it's a filing in federal court. And if you do that and you go to Mrs. Brown's Schedule F, you'll see that she lists among her unsecured creditors, that is, the people to whom she owes money, thousands of dollars of unpaid medical expenses. So what does it mean to say that Mary Brown decided not to buy health care? It means that all of us are paying for her health care. We're either paying through the government, which has to reimburse at higher rates for Medicaid and Medicare to take care of the risk of non-payment, or paying for it through our health insurance, because our health insurance costs go up because those of us who have insurance get socked with enough to pay for all of the care that healthcare providers are obligated to provide. So to say that she and other people like her are not affecting the national economy by their choices is to cut off the causal chain at the wrong place. And Justice Jackson was right about that. Moreover, Justice Jackson was right in his second point, and this is a point that I think people have lost sight of, which is the difference between the court of Robert Jackson and the court of today has to do in large part with whether or not they respect the political process, whether they respect the outcome of the democratic process. In contrast to Justice Jackson's view that Congress was better capable of resolving economic disputes than the courts, the majority of the current court think they're better capable of resolving every dispute, ranging from who won the election on down. Now perhaps some of that is because none of the current justices has ever served in elective office. None of them has been elected to Congress. None of them has been elected as governor. None of them has been elected as dog catcher. And they made choices early in their lives not to be involved deeply in the partisan political process. And no surprise, they don't think it does a very good job. And we can talk in the question and answer session about the extent to which the Supreme Court's own decisions make the political process operate worse than it otherwise might. But they have very little sense of the political process, very little respect for it, and therefore they are unlikely to uphold or to apply statutes in the way that the people who passed them intended for them to be done. And that's an important thing to realize about this Supreme Court. This Supreme Court is not respectful of the democratic process. Even when they uphold statutes, they say really nasty things about them. I can't think of a case like the Affordable Care Act where an act ultimately got upheld by somebody who said as many nasty things about it along the way. Now, Justice Jackson's perspective on when the court should intervene and when it should stand back is also evident in one of his most famous dissents. Fred Korematsu was an American citizen who challenged his conviction for remaining in California after a military order during World War II excluded all persons of Japanese descent. There was a military order that ordered all Japanese citizens and all American citizens of Japanese descent off of the West Coast and herded people into camps in the central part of the country where they were interned for the entire war. A majority of the Supreme Court, after a little bit of hand-wringing, upheld the conviction. We now know that that decision was terribly, terribly wrong. We now know that the government suppressed documents showing that there was no evidence to support the exclusion and subsequent internment of Japanese Americans. Indeed, in 1988, Congress issued a formal apology for the suffering and loss of property that the internment had caused, and in 1989, it authorized reparations of $20,000 apiece to each of the approximately 60,000 survivors of the internment camps. If you read Earl Warren's biography, there's a wonderful biography of Earl Warren. One of the things that suggests there is, although he never admitted that he was mistaken as governor of California to support the internment, a number of people attribute his support for civil rights and civil liberties when he got to the Supreme Court to his recognition that he had been part of something that was an outrage. So the Supreme Court is not always right, and it doesn't always protect people's rights in wartime. But Justice Jackson was one of 3 dissenters on the Supreme Court. Now, much of his dissent would seem totally conventional to you today, where he talks about the wrongness of stereotyping people based on race or ethnicity or ancestry, and the lack of evidence that Japanese Americans aren't just as loyal citizens of the United States as anyone else. He wrote powerfully about the wrongness of racial discrimination and stereotyping. But he made a more subtle point as well. The court, he said, should not really even pretend to pass on the legitimacy of the underlying military order excluding Japanese Americans from the West Coast. Because almost inevitably, during wartime, the court will defer to military judgments without requiring the usual kind of justification that it demands. That is, if the Secretary of Agriculture does something, the court will look at it pretty carefully. But if the Secretary of Defense does it during wartime, the court is going to be very, very hands-off. And here's what Justice Jackson said the danger is about courts pretending that they're performing their usual function. He says, a military order, however unconstitutional, is not apt to last longer than the military emergency. Even during that period, a succeeding commander may revoke it. But once a judicial opinion rationalizes such an order to show that it conforms to the Constitution, or rather, rationalizes the Constitution to show that the Constitution sanctions such an order, the court for all time has validated the principle of racial discrimination in criminal procedure and of transplanting American citizens. The principle then lies about like a loaded weapon, ready for the hand of any authority that can bring forward a plausible claim of an urgent need. Every repetition embeds that principle more deeply in our law and thinking and expands it to new purposes. So the point that he's making is an important one, which is if courts are not going to perform their really independent function, they would be best off to just admit that. That's his first point. And that message holds, I think, urgent resonance for us living today in the age of terror. Consider two examples of current policies. One of them is sometimes referred to by the euphemism of enhanced interrogation techniques. Not to put a fine point on it, enhanced interrogation techniques involves questioning prisoners in ways that would be understood as torture if we used them on suspects in regular criminal cases. Things like sleep deprivation, waterboarding, stress tests, physical violence. A decade ago, Professor Alan Dershowitz proposed that we consider torture warrants, authorizations from judges to use what he called non-lethal means such as sterile needles inserted beneath the nails to cause excruciating pain when a suspect won't tell us where a ticking time bomb is. But what Justice Jackson is telling us, I think, is that there is a serious danger to the fabric of law here. When the government comes to a judge without any argument from the other side and asks for a torture warrant, what is a judge likely to do? The government tells him there's a ticking time bomb. The government tells him there is no other way to get the information we want. We want to torture somebody. What's a judge likely to do? He's likely to grant that warrant. And what precedent will that set for the future? That's Justice Jackson's first point. And the second example I want to give is true for targeted killing, which is a blander way of saying the United States is engaged in assassinating people it can reach overseas, including American citizens like Anwar al-Awlaki. Now, we live in a different world from Robert Jackson's. There, the enemy who attacked the United States was the Japanese Empire. We knew who they were. They were a nation. They were a nation with a clearly defined territory and clearly defined military force. When we found spies, we executed them summarily. But we understood what the military was and we understood what civilians were. In 2001, however, the enemy who attacked the United States was Al-Qaeda, an amorphous entity with operatives throughout the world who don't wear uniforms. And the battlefield isn't a narrow place, but it's potentially anywhere in the world where Al-Qaeda can operate. Fighting Al-Qaeda means going after individuals individually in a way that fighting the Germans or the Japanese in World War II did not. In this frightening new world, uses of military force may start to resemble conventional criminal punishment. For example, if we had learned that al-Awlaki was living in Cairo, Illinois, instead of in Yemen, he would have been arrested and tried, and if convicted, he would have been punished. We never would have simply hired sharpshooters to shoot through the window of the house and kill him where he was sitting. So this raises, I think, an important question of whether the military and not the judicial system should be making judgments about who the United States should target overseas. But what Justice Jackson is reminding us of is if military operations and the criminal justice system start to converge, the citizens that have considerations that have traditionally informed one are going to spill over to the other. That That is, both systems are going to be altered. It's not that we're going to just judicialize military operations, but we may militarize normal law enforcement, and that will impose a cost on the country and on civil liberties. He's warning us that we should not pretend that courts and normal law won't be influenced if we change the way that we think about the war on terror. That being said, it's also important to remember Justice Jackson's bottom line in Korematsu, which is he didn't just say, well, we shouldn't say anything about the military exclusion order. He went on to say something else, which is even if the military is going to exclude people, the courts don't have to participate in that by upholding the conviction of somebody who resists the military order. And so he said about Fred Korematsu, I should hold that a civil court cannot be made to enforce an order which violates constitutional limits, even if it's a reasonable exercise of military authority. The courts can exercise only the judicial power, can apply only law, and must abide by the Constitution, or they cease to be civil courts and become instruments of military policy. Notice what he's doing here. He's separating two realms. While the courts shouldn't interfere in military affairs, they also shouldn't become complicit when that authority is invoked. And that message has special resonance for us today. We need to be very careful that we don't create loaded guns that lie around for future governments to use. It's an exquisitely difficult area of law, but Justice Jackson, I think, is giving us some real tools for thinking about it. Now, in the term between Wickard and Korematsu, Justice Jackson wrote one of his most powerful opinions for the Supreme Court in a case called West Virginia State Board of Education against Barnett. The case involved the question of whether a state could force school children to say the Pledge of Allegiance. For those of you in the audience who are my age or younger, you remember the Pledge of Allegiance in one way. For people who are over about the age of 75, you will remember it in quite a different way, which is at the time that Justice Jackson was writing his opinion, this is how this Pledge of Allegiance was said. It also didn't have the words "under God" in it, but you said it with your hand like this. And the case is being decided in 1943, and if you think about this, it looks a lot like this. And because this looks a lot like this, we now do this. So the state of West Virginia told school children that if they didn't say it, they'd be expelled from school and their parents would be prosecuted for encouraging delinquency. And young Jehovah's Witnesses refused to say the Pledge of Allegiance. Now, 3 years earlier, the Supreme Court had upheld a similar law from Pennsylvania. But this time around, under Justice Jackson's leadership, the Supreme Court, in a divided opinion, struck down the statute. Now, our country was in the middle of a war. And the Board of Education argued that national unity is the basis of national security, and requiring everyone to say the pledge was an appropriate way of getting people to be unified. But this is what Justice Jackson said. Struggles to coerce uniformity of sentiment in support of some end thought essential to their time and country have been waged by many good as well as by evil men. As governmental pressure towards unity becomes greater, so strife becomes more bitter as to whose unity it shall be. Ultimate futility of such attempts to compel coherence is the lesson of every such effort, from the Roman drive to stamp out Christianity as a disturber of its pagan unity, the Inquisition as a means to religious and dynastic unity, the Siberian exiles as a means to Russian unity, down to the fast failing efforts of our present totalitarian enemies. Those who begin coercive elimination of dissent soon find themselves exterminating dissenters. Compulsory unification of opinion achieves only the unanimity of the graveyard. And he said, we know that there is a lot to be uncomfortable about, but we have to be comfortable with discussion and debate. We apply the limitations of the Constitution with no fear that freedom to be intellectually and spiritually diverse, or even contrary, will disintegrate the social organization. And he made the point that the very fact that we were at war and that something critical was at stake made it even more important to tolerate dissent and conscience. He said, freedom to differ is not limited to things that do not matter much. That would be a mere shadow of freedom. The test of its substance is the right to differ as to things that touch the heart of the existing order. If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. If there are any circumstances which permit an exception, they do not now occur to us. That commitment to freedom, even when it involves fundamental issues of policy that touch the existing order, is the absolute heart of the First Amendment as it survives today at the Supreme Court. Justice Jackson's words have protected generations of dissenters, and they continue to do so today. Now, my final example for you today is going to involve an issue that seemed, when it got to the Supreme Court, even more trivial than Farmer Filburn and his 239 bushels. It's a case called Railway Express Agency against New York. Now, New York City had a traffic regulation that forbid motor vehicles from displaying advertising on their sides unless the advertisement was for the owner's business. They actually wanted to forbid all advertisements on the sides of trucks, but the newspapers in New York City were very powerful and said, no, we want to have, and the New York Times wants to have New York Times on the side of its truck, or the Herald Tribune, which was then around, or the New York Post or the Daily News, right? So that as they traveled around the city, they could do this. Now, Railway Express was basically a precursor of UPS and FedEx. It delivered packages. And it wanted to put ads on the side of its trucks for, among other things, Camel cigarettes, Ringling Brothers and Barnum and Bailey's Circus, and the U.S. Navy. Not one ad. These were three different ads. It was not, you can fly on the high-end flying trapeze while getting cancer and serving in the Navy. So they wanted to put these ads on the side of their trucks, and they challenged the New York ban because they said, look, you're interfering with our freedom, which violates our liberty under the 14th Amendment's protection of liberty. And by the way, you're treating us differently than you're treating businesses that want to advertise their own goods. And that violates the Equal Protection Clause, because you're treating two groups of people unequally, right? Two groups of people running trucks that want to have ads, one gets to run them, the other doesn't. And they say, this violates our rights under the Constitution. And as you heard in the question and answer session earlier, although Railway Express is a corporation, its liberty is protected under the 14th Amendment, because since the 1880s, the Supreme Court has read the Due Process Clause of the Supreme Court of the Constitution to protect corporate persons as well as natural persons. So that's what the case was about. And it doesn't really sound like a very momentous constitutional case. And indeed, in some ways, it isn't. The Supreme Court unanimously upheld the regulation. And the majority opinion, the opinion for the court, is not particularly interesting, except as an example of how absolutely toothless the Supreme Court can be when it wants to be in reviewing a law. So what the justice said is, well, we can come up with an explanation of why this law makes sense that isn't just it's self-dealing for the newspapers. Maybe the city thought that there was less in the way of disruption from the ads of businesses that put their own names on the truck than from other businesses. Now, why would that be? Okay. Or maybe there's less of a traffic problem from those ads. The Supreme Court sometimes, when they want to be, they can be extremely inventive in coming up with reasons for things. My favorite example is a case called Koch against Riverboat Pilots, where the state of Louisiana essentially said you couldn't be a riverboat pilot, which was a very lucrative job, unless a current riverboat pilot took you on as an apprentice. And the riverboat pilots would only take on their own kids as apprentices. So you couldn't be a riverboat pilot unless your father was a riverboat pilot. And that case went up to the Supreme Court, and the Supreme Court said, well, here's what we think might be an explanation of this. Not all the lore of the river is written down. And so maybe having a riverboat pilot, maybe growing up on the river and kind of imbibing it at the dinner table and having a current pilot who really cares about you makes a difference to how good a riverboat pilot you're going to be. Yeah. Yeah, exactly. So the majority opinion, totally, nobody reads the majority opinion in Railway Express anymore, except for the proposition that when the Supreme Court wants to uphold a statute that's really stupid, they can do it. The real importance of the case, I think, lies in Justice Jackson's separate concurrence for himself alone. There, Justice Jackson advanced what I think is the most powerful description ever of the relationship between due process, between liberty, and between equal protection. And here's what he wrote. The framers of the Constitution knew, and we should not forget today, that there is no more effective practical guarantee against arbitrary and unreasonable government than to require that the principles of law which officials would impose upon a minority must be imposed generally. Conversely, nothing opens the door to arbitrary action so effectively as to allow those officials to pick and choose only a few to whom they'll apply the legislation, and thus to escape the political retribution that might be visited upon them if larger numbers were affected. Courts can take no better measure to assure that laws will be just than to require that laws be equal in operation. Justice Jackson was right. Like the two hands that emerge from the sheet of paper to draw one another in the famous etching by M.C. Escher, the ideas of equality and liberty expressed in the 14th Amendment each emerge from and reinforce each other. In a sense, then, Justice Jackson has offered us a constitutional version of the Golden Rule. A majority must do unto others what it would do unto itself. Or as Justice Scalia, also known for being a great stylist, later put it, our salvation is the Equal Protection Clause, which requires the Democratic majority to accept for themselves and their loved ones what they impose on you and me. And thus, Justice Jackson, although he would not have foreseen this himself, has given us a powerful answer on one set of fundamental constitutional issues now before the Supreme Court, namely the issues involving marriage equality. Constitutional law has long treated marriage as so important an institution that even discrimination that's otherwise permissible is not permissible when it touches on marriage. For example, prisoners may be denied many of the privileges of everyday life, but they must be allowed to marry. And fees can be charged by the government for access to most forms of governmental service, including most access to the court. You actually have to have enough money to pay the filing fee in order to go bankrupt. But the Supreme Court held that you cannot impose a filing fee for divorce, because the right to get married and to dissolve marriages is so fundamental to what makes us human that it can't be denied. It's a fundamental liberty. And precisely because the freedom to marry the person one loves is so central a feature of many individuals' existences, any restriction that denies access to marriage to a large group of people demands special skepticism. That's not to say that the restrictions are always invalid. We have a good reason, for example, to deny 14-year-olds the right to marry, even if Romeo and Juliet's a very inspiring play. But just that we should be really, really careful not to deny this liberty without a very, very good reason. So in Loving against Virginia, for example, in 1967, the Supreme Court of the United States struck down Virginia's ban on interracial marriage on both equal protection and due process grounds. It said, this is a law designed to maintain white supremacy, and therefore it violates equal protection. But at the same time, it also violates the Liberty Clause of the 14th Amendment, because denying people the freedom to marry that's long been recognized as one of the vital personal rights essential to the orderly pursuit of happiness by free men is unacceptable. Now, the same answer, I think, should be given to same-sex couples who argue that they have the right to marry. Straight couples would never accept a world in which the government failed to provide recognition and protection of their families. Why should same-sex couples be any different? Liberty and equality backstop each other here too. Now, I want to end by saying that Justice Jackson didn't just have an influence on the United States. He had an influence in his thinking as a justice on the world. A couple of years ago, I had dinner with Justice Albie Sachs, who sits on the South African Constitutional Court. And if you want to read what I think is one of the most inspiring judicial autobiographies ever, you ought to read his autobiography, Soft Vengeance of a Freedom Fighter. Albie Sachs was a civil rights activist in South Africa. He was arrested and held in solitary confinement for months on end. Ultimately, he went into exile. While he was in exile, the South African Secret Service planted a bomb in his car that blew up, blowing off one of his arms and blinding him. After the end of apartheid, he was back in South Africa. He helped to work on the Constitution, was named to the South African Supreme Court. And when I was having dinner with him, Albie Sachs asked me to guess who his favorite U.S. Supreme Court justices were. And the first one was super easy, which was William Brennan. Because they share the same outlook on what a constitution means, on criminal justice issues, on racial justice issues, on free speech issues. And so that was an easy one. He said, now guess the second one. No one ever guesses this. And I thought for a minute, and I said, Robert Jackson. And he broke into this big smile, and he said, why did you say Robert Jackson? I said, because you are a beautiful writer, and he was a beautiful writer, and I think you probably found some inspiration in his writing. And he said, that's exactly right. And so I want to read to you from what Justice Albie Sachs said in the South African Constitutional Court's decision in the National Coalition for Gay and Lesbian Equality against the Minister of Justice. And this was what he said in voting to strike down South Africa's sodomy statute. The fact is that both from the point of view of the persons affected, as well as from that of society as a whole, equality and privacy, which is one form of freedom, cannot be separated. Laws that deny rights to gay people, that straight people take for granted, deny equal respect for difference, which lies at the heart of equality and becomes the basis for the invasion of privacy. At the same time, the negation by the state of different forms of intimate personal behavior becomes the foundation for the repudiation of equality. Human rights are better approached and defended in an integrated rather than a disparate fashion. The rights must fit the people, not the people the rights. This requires looking at rights and their violations from a person-centered rather than a formula-based position and analyzing them contextually rather than abstractly. And I think you can see in that passage from Justice Sachs all of what I was talking about in the work of Justice Jackson. And I hope this shows you why Robert Jackson remains such a foundational figure in thinking about constitutional issues today. And now I'll take questions. Thank you very much.
You would line up with the microphone. We will take questions until 5 after 5, and then Pam will sign books.
I'm somewhat confused. As you went up the chain of command getting to the Supreme Court, which is the final arbiter of what the law is going to be, isn't there a redress that Congress can change that law? And can you name some of those that have been changed?
Yeah, so
overturned, I should say.
Sure, so there are two kinds of decisions that the Supreme Court really renders. One are constitutional decisions and the other statutory decisions. In a statutory decision, they're interpreting a law that Congress passed. And Congress can overturn the Supreme Court's decision there anytime it can get a majority together. So just to give one example, we represent, I teach in a clinic at Stanford where we represent people at the U.S. Supreme Court. We represented a woman named Lilly Ledbetter a couple of years ago. The Supreme Court issued a very restrictive decision of what the Civil Rights Act of 1964 means with respect to certain kinds of claims of unfair pay treatment. Congress overrode the Supreme Court's decision, and President Obama, the first major bill he signed into effect was the Lilly Ledbetter Fair Pay Act of 2009. Now, you can all applaud that, except the problem is Lilly Ledbetter basically gets, a T-shirt that says, Congress passed a law in my name and all I got was this lousy T-shirt. She doesn't get her money back that she lost during all of those years that she was underpaid. So, statutory decisions, the Supreme Court rules and Congress overrules them, I wouldn't say all the time, but pretty frequently. Constitutional decisions, by contrast, when the Supreme Court issues a constitutional decision, Congress can't simply say we disagree with your decision about the Constitution. Because at least for the time being, the Supreme Court's view on those are final. But the Supreme Court itself often overrules prior decisions. The Barnett case, the flag salute case I talked about a minute ago, that was a case where they overruled an earlier decision by the Supreme Court called Koch. And the other way that Supreme Court decisions get overruled is they get eroded over time as people change their views of what the Constitution really means. So for example, the Supreme Court in 1896 in Plessy against Ferguson held that racial segregation was all right under the Equal Protection Clause, that separate but equal was perfectly fine. Well, it turned out it was always separate and it was never equal. By 1954, when the Supreme Court decided Brown against Board of Education, the words of the Constitution hadn't changed. The words were what they had always been. But our understanding of what it means to give people equal protection of the law has changed. And I'll just say one very brief thing here, which is, I'll be citing books later, but you can actually get the earlier version of the book for free if you want it by simply downloading it. If you go to the American Constitution Society's website and just look for Keeping Faith, you can get Keeping Faith with the Constitution, you can get the book. But our point there is, we overrule the Supreme Court quite often. The Supreme Court, the Warren Court, which everybody thinks of as the kind of highlight in some ways of civil rights and civil liberties, thought it was okay to exclude women from juries. By the 1970s, the Supreme Court said, no, that denies people a fair cross-section. The Warren Court thought it was okay to deny people the right to enter the United States as immigrants if they were homosexual. Today, the Supreme Court would never uphold a law like that. Some of the justices would like to, but I don't think the majority of them would. And that's because over time, our society changes to reflect, our understanding of the Constitution changes to reflect our society. Now, do understand, and I understand this as a liberal all too well, that it's not a one-way ratchet. It's not that we're getting better in every way. There's a wonderful line of George W. Bush's, I believe we're on an irreversible course to more freedom and liberty, but that could change. He's right. He's right. And interestingly, the Supreme Court did something this term that indicates that, which is they had a case in front of them about whether the government needs a warrant to put a GPS device on your car. Justice Scalia wrote the opinion for the court, and he said, well, since in 1789 it would have been trespass to put a little constable on the back of your horse cart, this is trespass, it's a search. Justice Alito wrote an opinion for 4 members of the Supreme Court concurring in the judgment. Remember I told you that's when you get there by a different route? Saying this was a search, but this was a search because today people understand that putting a GPS device on your car for a long period of time is not something that you expect. But if that were to change, then the Fourth Amendment would change as well. And so when you talk to like your children or your grandchildren or other teenagers, you're sometimes shocked by the stuff they'll put online about themselves. Well, if people start doing that a lot more, then our understanding of privacy will constrict rather than expand. And the Supreme Court, 50 years after it begins to constrict, will interpret the Supreme Court in a restrictive way. Will interpret the amendment that way. Yeah.
I understand that the Affordable Health Care Act consisted of about 2,000 pages.
Yes.
I suspect that the
Important liberty or important equality. That is, he thought this was so trivial. But what he was really pointing out is the court shouldn't have treated them as 2 separate questions. It's a stupid law, but is it a law that really deprives anybody of an important liberty? No, not really. Is it a law that really treats people super unequally? Again, no, not really. Thank you.
I'm assuming that the word corporate persons means treating a corporation as an individual. How can we have a government by for the people if the individual can never stand up against the unlimited resources of a corporation?
Well, that's a good question. It's a question about which the current Supreme Court has made up its mind. This year, the Supreme Court had an opportunity to rethink what they had done in Citizens United. What the Supreme Court did in Citizens United and a series of other cases is not so much say that corporations were people. That had been kind of recognized, and indeed I think most of you wouldn't disagree that, say, the New York Times has a First Amendment right to publish a newspaper, or that the Sierra Club, which is also a corporation, has a right to say things about the environment, or for that matter, the National Rifle Association, which is a corporation, has a right to say things. The question isn't so much that as what limits ought we to allow on particular kinds of speech, because free speech is not the only value in the Constitution. I think that's part of what you're getting at. government by the people, that is democracy and equality is as well. So we don't allow, for example, rich people to have more votes than poor people, right? That's what one person, one vote is about. And the worry is that if you allow unlimited spending on elections, money will be translated into votes. And over time, that will undermine our democracy. And the Supreme Court had an opportunity to think long and hard about that this year in a case from Montana. Montana has a history of corporations just outright buying judges and buying state legislators at the turn of the 20th century. I mean, it's just well-documented history. And so Montana passed a ban on corporations spending money on elections in Montana. And the other thing is Montana has elected judges. Unlike the federal system, judges in Montana are elected. And judicial elections are an area where corporations spend money and not very many other people do. And so they can have a huge impact on who gets elected and therefore who decides product liability cases and consumer rights cases and employee rights cases and all down the line. So one of the things that Montana did is it said, look, we have evidence. I understand, Montana said, we understand that Congress didn't have much evidence, although we're now starting to see a fair amount of it come out, that lots of money is sloshing into the system. But Montana has this evidence. So why can't we keep our law? And the Supreme Court didn't even bother to hear the case. They just summarily, which means no oral argument, no full briefing, they said, Montana, you got our decision, Citizens United, wrong. Your law's unconstitutional. And the 4 justices who think Citizens United was badly decided, that is, that the government ought to be able to limit corporations' speech because corporations have advantages that the rest of us don't have. They pay different taxes than the rest of us do. They have unlimited life. They have limited liability, right? I mean, there are all sorts of reasons why corporations are a different kind of person than you or me. That's why we don't allow corporations to vote. Why we call it a merger, not a marriage, when 2 of them get together, right? The 4 justices who thought Citizens United were wrong issued like a 1-paragraph statement that just said, we think Citizens United's wrong, we think this illustrates what's wrong, but you know what? We can see there's not a 5th vote. The other 5 of them, they just made up their mind, they're not going to change their mind, so what's the point in having an argument? And I think until we change who's on the Supreme Court, that's not going to change, right? And the real problem here is who gets on the Supreme Court is itself a product of the elections. And the elections are now a product of the world the Supreme Court has provided. And I'll just end with one real irony here, which is the Supreme Court says in Citizens United, you know, people shouldn't lose confidence in the election system just because